Tennessee is now in session.
Good afternoon and welcome everyone to the December session of the Tennessee Court of Criminal Appeals. We're holding this particular session. This is the third case today by way of Zoom oral arguments. They're being live streamed over the internet on YouTube, and you can find them at TN Court's channel. We wish to take this time to thank the lawyers for appearing and using this technology and their willingness to help us. Also, Clerk Jim Hivner and his staff, the staff of the AOC for making all of this possible. We would prefer to be in person, but it is our attempt to help be a solution to the spread of COVID, and we are trying new technology to help us minimize any possibility of spread. And at the same time, it helps us keep our cases moving along in a very timely manner. I'm also happy today to be joined by the judges that are with us. To my left and your right on the screen is Judge Ross Dyer from Memphis, Shelby County, Tennessee. And on my right and your left, Judge Camille McMullen from Memphis, Tennessee, Shelby County. And I'm John Everett Williams from Huntingdon, Carroll County, Tennessee. We're delighted to be your panel today. These cases today will proceed in the same manner that they do when we hold in-person hearings. Each side is awarded 20 minutes to address the court, and the appellant may reserve a time for rebuttal, and you should do that when you introduce yourself to the court. With that, is there anything from the judges? Seeing nothing, Madam Clerk, would you please call the third case of the day?
State of Tennessee versus Jadarius Foster.
The appellant may proceed, and I will try to help you keep up with your time, and your time will begin now.
Thank you, Your Honor. Good afternoon, Your Honors. May it please the court. My name is Jessica Butler with the Appellate Division of the Public Defender's Conference, and I represent the appellant, Mr. Foster. Your Honor, I'd like to reserve 3 minutes for rebuttal.
Yes, ma'am.
Thank you. So for the court's benefit, as well as anyone who may be tuning in today, I'd like to begin with just a brief overview of the facts. Mr. Foster was driving on Highway 18 in Madison County on February 23rd, 2019. There are differing narratives from the officers on some of the things that transpired after this, but the general consensus is that at some point, Mr. Foster's vehicle drifted in the lane, and at one point he hit both the fog line and the center lane line of the highway. Based on this, the two officers initiated a traffic stop. I say differing narratives because, unfortunately, there was no body camera. Neither of the officers were equipped with body cameras, and the cruiser that they were riding in did not have a dash cam. Nonetheless, Deputy Fitzgerald is the one who initiated the stop. He said that he intended to give Mr. Foster a warning citation. So he approached the vehicle, asked for license and registration, ran his identification. Mr. Foster had no outstanding warrants. But instead of giving him the warning citation, he asked Mr. Foster to step out of the vehicle, patted him down for weapons, and asked for consent to search the vehicle. Mr. Foster denied consent. At that point, Officer Fitzgerald stated that he had seen a digital scale on the back seat of the vehicle and asked Mr. Foster if there was anything illegal in his car. According to Deputy Fitzgerald, at this point, Mr. Foster admitted to having a small amount of marijuana in the vehicle. Deputy Fitzgerald then used this as probable cause to search the vehicle. Although he told Mr. Foster that he was not concerned with a small amount of marijuana, he also asked if there were any weapons in the car, and Mr. Foster admitted to owning a handgun that was also in the vehicle. The subsequent search of the vehicle yielded the gun, the digital scale, and the substance that the officers assumed was marijuana. Based on that, Mr. Foster was charged with improper lane change, possession of drug paraphernalia, and theft because the weapon was found to have been stolen from a store in Corinth, Mississippi, 6 months earlier. For today's purposes, we are challenging the sufficiency of the evidence on the theft as well as the possession of drug paraphernalia. So I'll actually begin with the theft. The state's entire case really rested on the permissible inference that a person who is found in possession of recently stolen goods came into possession of those items via theft. This gun that was found in Mr. Foster's vehicle was one of 10 weapons that was taken from the gun store in Corinth, Mississippi in August of the previous year. The store owner said that there was video surveillance, but the state did not submit that evidence at trial. And the owner also gave no description about who these individuals were. No description on height, build, race, even gender. So for all we know, these individuals look nothing like Mr. Foster. The state simply did not put on that proof. So really the only thing that the state had in terms of evidence of theft was this inference that Mr. Foster committed the theft because he was in possession of one of these items.
Counselor, can we also not use a couple of other things in looking at this, like the fact that, if I understand correctly, he was, at least it appeared to the officer, they were trying to wedge the gun down in between the seats so it couldn't be seen. He denied that he had a weapon in the car. He immediately, upon them finding the weapon, told him, "Oh no, it's not hot. It's not hot." I mean, can we not use all of that as well, in addition to the fact that it's recently stolen property?
I think it's possible to draw on all of those pieces. But in terms of the actual evidence that was submitted at trial, we really only have that this was a recently stolen item. And when you look at this situation kind of in its full context, the fact that it was quote unquote recently stolen, I think even that's arguably in dispute. There was a 6-month time frame between these two incidents.
Why isn't that something that the jury determined? Because what we're talking about here is really what the jury is instructed on in terms of the permissible inference. Am I right in that, counsel?
That's correct.
So in the trial court's instruction, and you're not disputing that the trial court properly instructed the jury in this case?
No, Your Honor.
Okay. Within the instruction, isn't there some language in there that gives the jury the ability to make that determination?
There is, Your Honor. Obviously, recently stolen, recently is left somewhat purposely ambiguous for the jury to have some leeway in deciding that. And so we're really not arguing that there's an issue with the inference itself. It's more how far can that inference be extended? At what point is the state's reliance on that inference no longer useful? And when you think about the time frame between these two incidents, the fact that the gun store is, almost 50 miles away from where Mr. Foster was stopped, and then you think about the nature of this item. This is not an appliance. It's not something that's easily movable. It's a weapon. And even with legal sales, it's very common for a weapon to change hands 2 or 3 times in the span of a few months, whether it be through private sale or auction or something of that matter. So I think the nature of the item here also matters. And when you look at that in context with the fact that the state had no other evidence to place him there, I think at that point you have to question whether the state can rely purely on that inference to secure conviction.
Well, then I'll go back to Judge Dyer's question, because Judge Dyer's question, there is other evidence. It's not just based on the mere inference. The police officer in this case testified that, number one, he lied about there being a gun in the car. Number two, that he saw him pushing the gun down between the seats. You don't consider those things, back to Judge Dyer's question. Do you consider those things to be additional evidence? Can we consider those things?
I think the court can consider those things. And I guess our argument would be that even with those additional facts, there's still not enough here to secure a conviction on the theft. Maybe, possession of stolen property or something of that level, but not the theft itself. Those are obviously very different accusations. So it's possible that, he was in possession of, we're not disputing, obviously, he was in possession of stolen property. But for that to rise to the level of theft with no other evidence other than the inference itself, we would argue that that's insufficient evidence.
Can I ask you this, counsel? Are you drawing a parallel to what we do with aggravated burglary, and when we require corroborating evidence on top of the inference? Is that what you are asking us to? Is that your argument? That's kind of what I got from your brief in terms of where you were going with this argument.
Sure, I think that's correct, Your Honor, that there has to be some type of corroboration, that the state, obviously, the state has the burden of proof here, and that the state has to provide something other than simply the inference. That the inference can assist their prosecution, but the inference cannot be their prosecution. And this is something that the Supreme Court has also dealt with somewhat briefly in Bush, which is cited in our brief. That mere possession of the item is not quite enough, that there has to be something else. Essentially, the court said that kind of the surrounding circumstances will give more weight to whether or not the individual found in possession of these items was the perpetrator of the theft. And again, when you look at the temporal issues, the distance issues, and the fact that this is something that through legal channels could have changed hands multiple times, it's very hard to see how these two situations are not so attenuated that the inference really becomes meaningless. And so for the state to be able to rely solely on that inference, even in the presence of some additional factors that maybe the jury could have considered, when the state is relying pretty much solely on that inference, we would argue that that's insufficient evidence to support the theft conviction.
With those additional factors that we talked about, that Dyer and I pointed to, would that be the type of evidence that the corroboration that you would be looking for in terms of connecting it to the actual theft? Would you have to have something? I'm trying to understand your argument in terms of even with those other two pieces of evidence, the lying, where it was found, that sort of thing. Those are in addition to the inference, correct?
Correct, Your Honor.
So
again, I think that those factors can point possibly to Mr. Foster being aware that the items were stolen, but not to the fact that he stole those items himself. The state called the gun owner, the owner of the store, at trial, but again, they had video surveillance. They did not submit that at trial. That would have been something that could have placed Mr. Foster at the scene of the crime. They didn't have the gun store owner testify to what type of individual perpetrated this crime. I mean, for all we know, this could have been perpetrated by, a woman, someone who looks completely nothing like Mr. Foster. But if they had submitted that evidence, that could have been additional evidence that would have made it an easier sell to say that Mr. Foster was somehow involved in the theft. Just the fact that he was potentially aware that the items were stolen is not necessarily enough to rise to the level of theft. Sure, the jury can consider those additional factors, but those factors don't necessarily point to theft. They point more to a knowledge of stolen property. The next thing I'll move on to is the possession of drug paraphernalia. And this is really another instance of the state relying on little to no evidence to secure its conviction. So in this instance, the only evidence that the state presented was that Mr. Foster was in possession of this digital scale. Even the state at trial referred to it as a kitchen gadget, and there was some testimony back and forth about the many non-nefarious uses for a digital scale.
Your client was also admitted to smoking marijuana or a blunt, and that was found in the car at the time, correct?
That's correct, Your Honor. So the officers did recover a substance, and Mr. Foster did say that it was marijuana, but the officers did not collect that as evidence. He was not charged with possession of
Does that matter?
The marijuana. I think it does, Your Honor. So the officers tossed that evidence into the grass. There was no field test done to confirm that it was marijuana. They did not, save some of it and send it to the TBI for testing. So we really only have the officer's senses that it was marijuana.
But counsel, they're not trying to prove that it was marijuana. I mean, what the testimony is that there was a blunt in the car, there was a half a cigarette in the car, and that's credible testimony. He's not trying to prove the offense of possession of marijuana. There's a difference between the two. Don't you agree with that?
I do, Your Honor. So
I can't discredit that testimony.
Well, the officer, even the TBI has said that it's very difficult for an officer to rely on his own senses to determine whether something is marijuana or a legal alternative. And without that field test, without TBI testing, we do not actually know that was marijuana. Even Mr. Foster could have been mistaken in his belief that it was marijuana.
Counsel.
Without that field testing, we don't know.
Okay.
Well, we see things called gambling devices, and if you find a pair of dice on a Monopoly board with 7 kids around it, it's generally a pair of dice. You find it on a green felt table with a bunch of grown men standing around it and dollar bills on the table, it's generally a gambling device. What are these kitchen scales doing in his backseat of his car? Isn't that a question for the jury to determine?
I think it is, Your Honor, but I think our bigger issue here is that the state is relying on the officer's testimony that this was marijuana with nothing to back that up. And that, again, that's all the state has. They discarded the evidence that would have for sure proven that these items were drug paraphernalia. And so I guess our argument is that the state can't discard the evidence and then rely on the inference that evidence existed to secure a conviction on the drug paraphernalia. That you have to have something else to prove that an otherwise legal item is, in fact, drug paraphernalia in this instance. There was no residue.
Would it be sufficient then if they had field tested it and then they threw it in the bushes, but then the officer could at least testify, hey, I field tested it and it came back as marijuana?
I think so, Your Honor. I think so. But they didn't do that. And so all we have is, again, the assumption that this was marijuana with the connection to a digital scale that if it were not marijuana would be perfectly legal.
Was there an objection to the officer's testimony in regard to marijuana?
There was not, Your Honor. There was not.
You're 15 minutes into your argument.
Okay, thank you, Your Honor.
And the defendant did say, at least according to the officer, I've got a small amount of marijuana in the ashtray. Is that not part of the
That is correct.
The defendant admits it's marijuana.
I would say that the defendant believes it was marijuana.
Okay.
But we don't have the field test to confirm that it was in fact marijuana. People get illicit drugs all the time that in fact are not what they think they are. So we have Mr. Foster's belief that it was marijuana. And we have the officer's belief based on his senses that it was marijuana, but we do not have definitive proof that it was marijuana. And in the absence of that, the state can't rely on the assumption of marijuana to say that Mr. Foster was in possession of drug paraphernalia when a digital scale in and of itself is a legal item to possess.
To allow you your full 3 minutes, we will hear from the state now.
Thank you.
General?
Thank you, Your Honor. May it please the court, Brent Sherry for the state. I'd like to go through these facts just a little bit more. The defense presented these facts in something of an abbreviated fashion. I think there are some details that deserve some attention. This happened in February of 2019. The defendant and a passenger were pulled over after they had drifted over the center and the fog line, and that part of the defense has presented correctly. As the deputy in this case approached the car, he shined his light in the car, and in the back of the car, on the floorboard behind the passenger seat, he saw this digital scale. So that was the first thing that kind of alarmed him. He approached the car. He spoke with the defendant, and he asked if there were any firearms in the car.
Counsel, you're skipping over or maybe my understanding is wrong in terms of the reading of the briefs, but my understanding was that he didn't see the scales until after he approached the driver and advised him why he was being pulled over and that he was going to get a warning citation. What was the chronology, or do I have the chronology incorrect? The scales were after the fact.
Well, Your Honor, I believe that it was as he was approaching the car that he shined his light in and saw the scales. And I think
upon initial approach.
That's my understanding from the testimony that night. And I'm just checking my my brief to see how I laid this out, Your Honor. As I read the transcript, he first addressed the defendant, asked if there was a reason why he swerved, and the defendant said that his vehicle was out of line. The deputy talked to the defendant and scanned the back seat at that point. So maybe it was after he had initially spoken with him and he scanned the back seat and saw the.
And the only reason why I kind of stopped you there, counsel, is because this was a little bit troubling to me, because the officer initially tells the defendant that he's going to let him go. He's just going to issue a citation. And then upon returning, there's some questions or inquiry into allowing him to or consenting to search the vehicle, or asking him to get down for a pat down search, or step out of the car for a pat down search, after the officer tells him that he's getting ready to release him for a warning or whatever. So what made me think that his mind changed about releasing him was upon his second approach to the car, possibly seeing the scales, but it wasn't clear to me on chronology how he changed from issuing a warning citation to asking the defendant to step out of the car for a pat down search. Does that make sense?
Yes, Your Honor, it does. And it's hard to know without asking more questions of the deputy exactly, where he was in the chronology and at what point he determined, hey, I need to look at this a little bit more closely. But I think it's pretty clear that he had a good reason for asking more questions and for pursuing what he perceived to be an issue with what he saw in the car. At some point, he saw that scale, and of course, what's the reason for having a scale, a digital scale in a car? It is a kitchen gadget. I have one. My kids got me one for Father's Day, and I use it to weigh pasta and other items when I'm cooking. I like to mess around in the kitchen a lot. But this isn't the kitchen. This is the back of somebody's car late at night, and he does have enough marijuana in the ashtray for a blunt, according to the defendant himself. So when we talk about that first issue,
counsel, do we associate a blunt with scales, or at least the definition of scales that the officer gave at trial? Do we associate personal use with scales, or what we look at as scales used in the drug trade?
I think we would, yes, Your Honor. The deputy testified that these scales are used in drug transactions. Transactions have two parts, a seller and a buyer. Either one could use a scale to measure what they're buying or selling.
Okay, well, I've got two responses to that. Was there testimony in regard to individuals' personal use, utilizing digital scales to weigh the amount that their seller is giving?
No.
I mean, that would make more sense to me in accepting your argument. But there was no testimony about an individual, I guess a user, carrying around digital scales to weigh what they buy from their seller.
Well, the testimony was that the officer testified, or the deputy testified, that these scales are used in drug transactions. And of course, in a drug transaction, there are two sides. And we don't have any specific testimony in this case, but we have seen cases in this court where transactions involve weighing on either side.
In most of these cases, though, where you're talking about scales amounting to paraphernalia, you're not talking about a small personal amount of marijuana being associated with them. You're talking about them being found in places where they're baggies or larger amounts of drugs or other packaging materials. Here you're talking about, best we can tell, even assuming the defendant and officer's version of it, a very small amount of marijuana that the officer wasn't even concerned about. And you're trying to say that whatever small amount that was, and the fact he has scales, all of a sudden make the scales drug paraphernalia. I mean, Judge Williams, I liked his analogy, but I think his analogy about dice is actually too far. You don't have here the green felt and a bunch of men and dollar bills sitting around and some dice. You have two guys sitting at a kitchen table and their dice there. And you're going to say, well, they're gambling. I don't know that you're there yet just because you have enough marijuana for a blunt.
Well, Your Honor, we kind of go back to the point of what is the purpose for having that in the car? Certainly, there needs to be something to tie.
He just picked it up from a friend's house who had borrowed it to cook and measure pasta. I mean,
I'll take you one further. It fell out of his girlfriend's grocery bag. I mean, this is not unreasonable to think about a person having a scale in their car for legitimate reasons outside of the drug trade.
I don't know about you, but I've got a kid and a wife, and I can tell you right now, if you went and looked in her car between the three of us and two dogs, no telling what's in the back of her SUV that, Judge Williams may tell me he's gambling. So has something to do with gambling. I don't know. And it's completely reasonable to be there because it's a family and it's in a car. And if you pulled me over at 12 o'clock at night, does that all of a sudden mean I'm doing something nefarious with it?
Well, Your Honor, I think, when we're looking at this scale, I think the jury could reasonably infer that there was something connected with drug transactions, and the defendant could certainly present evidence to counter that. But with nothing else, the jury could reasonably infer that this does have some connection with drugs or drugs in the car, and that's as far as we need to go. It's drug paraphernalia. The defendant had marijuana. He believed it was marijuana, and whether that was actually marijuana or whether it was oregano, that really doesn't matter. If he had marijuana and he thought it was marijuana.
What if the defendant had prescription drugs? His girlfriend had prescription drugs in her purse. And it wasn't, she didn't have her prescription bottle with her. She just had it in a Ziploc bag. But, does that make the scales all of a sudden drug paraphernalia?
I don't think so, Your Honor. Not in a case like that, where that's not the kind of thing that you would typically weigh and measure. Not prescription drugs. That's a wholly different kind of a scenario. But again, that's something for the jury to look at and weigh and balance and consider. So when we're looking at what is paraphernalia, we're looking at something that is connected with the use or ingestion or sale of drugs. And the jury could reasonably determine that this was drug paraphernalia. Now let's talk for a minute about the firearm charge, if we could. When the deputy approached the car, he asked the defendant if there were any firearms in the car. And according to his testimony, he said, "You're allowed to have them unless you're a convicted felon. We just like to know about it for our safety and yours." And the defendant denied that there were any firearms in the car. The officer continued to ask him questions about are there narcotics or are there any problems like that. And then he went back and he checked to see if there were any outstanding warrants. When he went back to check for outstanding warrants, the other deputy was on the other side of the car, and he watched and saw as the defendant stuffed something in between the driver's side seat and the center console.
How is this more than possession of stolen property?
Well, Your Honor, for that, let's look at the
Because he could lie about having the gun because he doesn't want to get caught for possession of stolen property.
Well, Your Honor, with when we're talking about the stolen handgun, the way that the statute is drafted here, first of all, there's no question that the defendant had possession of a gun and that it was stolen. That part is pretty easy. There's no question that the defendant exercised control over the pistol without the owner's consent. That part of the statute is met. It's a three element situation where we've got possession of a gun that was stolen, exercising control over it without the owner's consent, and knowledge that the gun was stolen. Possession of recently stolen property, and when we talk about recent, we're talking about 6 months in this scenario. And
is that recent for stolen?
That's a question. That's a question
for stolen property that's easily moved. I mean, to the defense's point, I mean, it'd be different if it were, a car or something big or heavy and this, that, and the other. But I mean, we all know, we've done this enough, that guns, especially stolen or illegal guns, are trading hands on a regular basis. So the fact that he has possession of it within 6 months, is that really recent for something that's easily distributed?
Well, when we look at the instruction that the court was given, the court talked about recently and what it means. And this is exactly what the court instructed the jury. The term recently is a relative term and has no fixed meaning. Whether property may be considered as recently stolen depends upon the nature of the property and all the facts and circumstances shown by the evidence in the case. The longer the period of time since the theft, the more doubtful becomes the inference which may be drawn from unexplained possession. But in this situation, yes, we do. I'm sorry, Your Honor.
No, go ahead and complete your answer. I'm sorry.
Okay. When we look at this situation, yes, 6 months, is that recently or is it not recently? And the jury can look at this and determine, based on that inference, that's where we begin. He certainly has this property. It certainly has been stolen. How recent was it? And what other circumstances do we have we can consider in determining whether this might be something that is a subject of a theft?
What's connecting him to this theft? That's what I think the question is. There's no question there. The defense is not challenging that the state was permitted to get the jury instruction on recent or stolen property, possession of stolen property, a recent stolen property, and the inference that goes along with that, the permissive inference that goes with that is left for the jury to decide. The question, I think, that I've not really heard a good answer from you, General, is really, can you base this conviction, the theft conviction, on the inference alone? And then secondarily to that, what about his mere possession of this recently stolen property connects him to this crime that occurred 50 miles away from where he was, and 6 months again, after it had occurred? There's nothing based on this record that I could see, or based in your brief, that shows he participated in any way in that theft. There's nothing that connects him at all. So in all the cases that I've read on this issue, there's some other evidence that's in the record supporting the conviction besides the inference. So can you speak to that?
Sure, Your Honor. First of all, when we talk about the inference, that's where we begin. He's got this property. The recency is something that can be debated, but he certainly has a property. And at that point, it's like, hey, tell us where you got this. That inference pushes him to say that he's got to make some explanation.
The burden flips to the defendant once you have an inference?
In this case, if it's not explained, the inference remains. But we have more.
You get the inference. I'm beyond that. You get it. Now what?
Now we look at the other circumstances. Well, first of all, let's look at the other circumstances. First of all, the officer comes to the car. He asks him, does he have any weapons in the car? And he explains to him in very clear terms, look, you have the right to have a weapon in the car. And it happens all the time. That's not a problem. But I just want to know about it so that we can all be safe. Oh, no, I don't have any weapons in the car. The defendant is clearly hiding the fact that he has this weapon in the car. And then he tries to hide it in between his seat and the console. Again, another act of trying to hide this weapon. Why does he try to hide the weapon? Because he knows it's stolen. Now, with this inference, the inference is only the beginning point. But the fact that he's lying about the weapon and that he's trying to hide it is suggested that he knows it's stolen and that he's has the intent to keep it from the owner, the rightful owner.
How is that theft from the store? How is that additional proof of theft from the Mississippi store that where the 10 guns were stolen from by 2 or 3 different masked individuals? How is that? How does that inference from him not wanting to tell the officer that he had a gun in the car, how is that additional proof establishing some sort of connection to the actual charge?
Your Honor, when we look at the charge itself, the way the statute is drafted, again, it has 2 parts, 2 portions. One has to do with obtaining the property, and the other one has to do with exercising control over the property and keeping it from the rightful owner. Our theft statute, this is the situation where the theft statute is applicable where the defendant has exercised control over this property and kept it from the rightful owner. And that is the theft. We don't necessarily have to go back and put him in the shop, taking the gun off of the rack. So,
Mr. Cherry or counsel, so the cases on aggravated burglary that talk about, you can't base a conviction. It's not the inference from possession of recently stolen property is not prima facie evidence that alone is not supporting of the conviction by itself. Those cases that specifically speak to aggravated burglary, that specifically say you have to have additional corroborating evidence that connects the defendant to the actual burglary, those cases don't apply here. Bush, James, all of those cases that talk about these permissible inferences and whether they can be standing alone supportive of a conviction. Because I think that's really what this case is about. They don't apply.
Well, I think when we're talking about a burglary is a little bit different than just a straight theft. When we talk about a theft, we certainly do have some corroborating evidence. We certainly know that this gun was stolen. And we certainly know that it was in the possession of the defendant.
But if the permissive inference can't be proof alone in a burglary, how can it be proof alone in a theft?
We have more than that here, Your Honor. We don't have just inference. We also have how he's acting after the fact, which establishes his guilty knowledge, his knowledge that this is stolen, that he has it, and that's really enough.
Okay.
I'm just looking over my notes here. I think the court has a pretty good handle on what our arguments are and what the position is here. This is an individual who, again, was rolling down the road late at night with a loaded, stolen handgun in his car and digital scales in the back and a blunt in the ashtray. Are the scales paraphernalia? Yes. Is this a theft situation where he can be convicted of exercising control over this property that he knew was stolen? It is a circumstantial case to a large degree, and the evidence is certainly enough to support the jury's determination that the defendant's guilty. As far as the fine is concerned, the defense has not brought that up during this argument, so if they're not going to raise it now, I will not. I'll rely on my brief for that portion of the argument today.
Thank you, General. Ms. Butler, you have your 3 minutes.
Thank you, Your Honor. I'll start with the drug paraphernalia issue. The deputy testified at the trial that scales, in his estimation, were used for weighing and packaging marijuana or some other type of drug. We certainly do not have any evidence of packaging the marijuana in this case. As to Your Honor's point, typically scales are deemed paraphernalia when we have additional evidence to go along with them, whether it be baggies or large quantities or residue on the scale. None of that is present in this case. In fact, actually in the drug paraphernalia statute, weighing items is actually not even listed in that statute. But of course, we have case law that says scales in accompaniment with other items can constitute paraphernalia. But we just don't have those other items here. Whatever the officer's intentions were for discarding the marijuana on the side of the road, essentially when they tossed that evidence and left it on the side of the highway, they left the state's case against Mr. Foster on the side of the highway as well. And so our argument is really that the state cannot rely on evidence it does not have to secure the conviction. And that's really what happened here. As for the theft, to the state's point, the theft has to be accompanied with some additional evidence. As Your Honor pointed out, we have the inference that a person in possession of the stolen goods took them via theft. But again, we do not have any other additional evidence linking Mr. Foster. And it's certainly not that the state could not present that evidence. They had, presumably they had the video surveillance at their disposal. They could have very simply had the owner testify to, what type of individuals were in the store. Mr. Foster was not found in possession of any other weapons, just the one handgun out of 10 that were stolen. These individuals supposedly broke in with baseball bats and ski masks. None of that was found in his vehicle either. So again, the state is really placing all of its chips on the inference alone. And again, as we said, we have no issue with the state using the inference to bolster its case, but the inference alone is not the conviction. And that's essentially what happened here. And so we would ask the court to vacate both the theft conviction as well as the drug paraphernalia issue conviction. And we will rest in our brief as far as the fines are concerned. Thank you, Your Honor.
Any questions from the judges? Thank both sides for the presentation today. We'll take it under advisement and we will stand adjourned until the call of the last case today at 2:00.
This honorable court is now in recess.